This is Left Voices for Thursday, March 13th, 2014. I'm Andrea Sears. Tonight,
I don't think judges have any business making secret law. It's not within their authority. Law belongs to us all. We, the people, are the sovereign.
Court rulings granting the government unprecedented surveillance powers remain classified. Recently revealed documents from NSA whistleblower Edward Snowden describe secret rulings issued by the Foreign Intelligence Surveillance Court that vastly expanded government authority to collect and disseminate information on American citizens. According to an article in the March 11th New York Times, in July 2002, 10 months after the 9/11 terrorist attacks, the Bush administration asked for and received what has been called the Raw Take Order, a ruling from the FISA court weakening restrictions on sharing surveillance data without first removing personal information on innocent Americans. That ruling, and many others, have taken the FISA court far from its original mandate, overseeing requests for surveillance warrants against suspected foreign intelligence agents inside the United States, to creating secret surveillance law through classified rulings. The Foreign Intelligence Surveillance Court was created by Congress in 1978. Its creation was based on the recommendations of the Church Committee, a Senate committee formed in 1975 to investigate illegal government spying on American citizens. Christopher Pyle was an Army intelligence officer in the 1960s when he learned that the Army had 1,500 plainclothes agents spying on the American anti-war movement. He became a whistleblower, testifying about the program in congressional hearings in January 1970. He went on to serve as a consultant to 3 congressional committees, including the Church Committee. Now a professor of constitutional law at Mount Holyoke College, Pyle says the Raw Take Order granted by the FISA court in 2002 was the beginning of the bulk surveillance of Americans' telephones, email, and Internet data.
And this is not what we intended when we created the Foreign Intelligence Surveillance Court. I testified against that, and I was a member of the staff of the Senate Select Committee on Intelligence that decided to go ahead with it. Our purpose in writing that law was to permit the CIA and the FBI to spy on foreign embassies and to plant bugs and to do wiretapping, although we only covered wiretapping in the law. The court eventually encompassed bugging as well. And as a result, when NSA expanded its surveillance with the Internet, we got a wholly new world, and there should have been new legislation at that point, but there wasn't, because the intelligence committees had become protectors of the intelligence agencies rather than overseers. And it's only been in the last week that the Senate committee has decided that it has an oversight function. Or at least the Democrats on that committee have decided they have an oversight function. The Republicans are not eager to do that.
The Foreign Intelligence Surveillance Court and the Foreign Intelligence Surveillance Act grew out of these scandals that were involved in COINTELPRO and other government surveillance programs. So it was really intended to control and rein in government surveillance, not to legitimize it. Has the court's purpose been significantly altered by not just approving warrants, but interpreting law?
Yes. I think that's very clear that the surveillance court's members have really betrayed the Fourth Amendment, betrayed the Constitution, by authorizing things in secret that they would never have authorized in public. This is a serious problem when judges become subordinate to the Justice Department, to the NSA, to the FBI, to the CIA. And that's what they've become. And one reason they've become that way is that they were chosen by the Chief Justice. That was another thing I opposed, but they went ahead and did it. And as a result, they put the selection of those secret judges, secret court judges, in the hands of a very conservative, pro-administration, pro-surveillance Chief Justice. And these folks, many of whom were selected eventually by the Federalist Society, which is a kind of an employment agency for conservative lawyers, pro-administration, pro-national security lawyers. And the court, with that kind of a staff, has gone ahead and rubber-stamped a good deal of material and activity that the old Church Committee would never have permitted.
The Foreign Intelligence Surveillance Court has a history of being a rubber stamp. In all the years of its existence, up until recently at least, there were very few instances when requests for warrants and other authorizations were denied by the court. Has the court really been a critical body? Has it been a deliberative, adjudicative body, or has it served simply as a rubber stamp primarily?
Well, it first became a rubber stamp for applications for warrants, pseudo-warrants, I call them, since they really weren't true probable cause warrants as required by the Constitution. It rubber stamped those applications. It turned down or required modification of very few of them. But after 9/11, the court went further and started making secret law, with making decisions interpreting the Constitution and the Foreign Intelligence Surveillance Act. And those interpretations vastly expanded the power of secret agencies. They could now operate and claim privately that they had legal authority to do what they were doing. But their court never heard from anybody opposed to the government's point of view. All of its proceedings were ex parte, as the lawyers say. One-sided applications, one-sided appeals, no adversary proceeding as is required by the Constitution and the common law. It was really quite corrupt.
What happens with information that may be gained through these secret rulings or through implementation of these secret rulings? If it gets to court, can it be challenged when the rulings that authorized it were secret?
It's virtually impossible to do it unless the court that hears the charge is willing to open up those court decisions for open court scrutiny. And the judges who made those decisions sealed those orders. In fact, they're still sealed. So we can't know fully what these different opinions said. And from what I can tell from secondhand accounts, the opinions did not begin to look at legal issues until midway through the decade. They just basically nodded approval. And they nodded approval to some very curious word interpretations. There's a term in the Foreign Intelligence Surveillance Act called facility. Well, that facility was supposed to be the phones of foreign embassies, foreign intelligence agencies. It wasn't supposed to be the whole bloody internet, but they allowed that to cover almost anything and everything that could be picked up electronically. Now, that means that the surveillance was not targeted anymore. It was totally untargeted. It was a situation where instead of having a search before a seizure, they had the seizure before the search. The NSA would collect enormous amounts of information with these pseudo-warrants or pursuant to the authorizations and without further judicial approval. They collect vast amounts of information for search by computer when and if they thought there was something worth searching. And that's the situation we're in today. All your phone calls and mine and everybody who listens to your programs have all their records on file with NSA, and the NSA can search them if it decides we're causing trouble. And it's not just terrorism trouble. It's almost any kind of trouble, including, let's say, in your case, as an investigative reporter and a news person, let's say you've got some informants who have not been identified, and the government wants to identify them so that it can silence them or so that it can prosecute them. It goes into your phone records and into your email records, and it finds that information. And then it shares it with the FBI, and the FBI may camouflage it in some way. It did that extensively in the 60s when it broke the law. It would pretend that wiretaps were really informants and confidential informants could not be disclosed when really they were illegal wiretaps. And so the receipt of information from illegal wiretaps could be camouflaged in the same way. But the government would figure out who your sources are and would silence them or people like them, intimidate people like them, intimidate reporters, and essentially shut down any disclosure of government wrongdoing.
It seems that there are two things that may be needed here. One is a review of FISA decisions. Is it possible to order or somehow compel at least an independent review of FISA court rulings?
I think there ought to be a public review of its rulings. I don't think judges have any business making secret law. It's not within their authority. Law belongs to us all. We, the people, are the sovereign. They're not the sovereign. They can't keep our business secret from us unless they're doing a few things that we've authorized by statute, such as protecting troop movements and informants and such in time of war and all that. But these folks are authorizing massive surveillance powers of secret agencies, and that was not what they were created to do.
Is it time for another church committee?
Yes. I'd prefer that the current intelligence committees wake up and do the job they're supposed to do. They will say there's no need for a church committee because they exist. And it could be, maybe, that one reason why the chair of the Senate committee, Dianne Feinstein, is finally taking the CIA on and charging it with violating the committee's privacy is that she's taking seriously these demands for a new church committee, which would be a repudiation of her trusteeship as chair of the successor committee. It's hard to say, because she has been conducting a behind-the-scenes battle with the CIA for several years, and as today's paper pointed out, with the White House. The White House is withholding 9,000 documents about the torture that should never have withheld. She's fought those battles behind the scenes. She's never taken them public. The fact that she's taking them public indicates to me that at least the Democrats on the committee or the Democratic chair is finally taking the criticism seriously. But of course the Republicans aren't, and that's the tragedy of it. The Republicans will not defend the prerogatives of the Congress. And it's the prerogative of the Congress to oversee the intelligence agencies and not to have the committee's work sabotaged by people who break into the committee's computers and steal documents and take them back so the committee can't use them in investigating the torture program.
Christopher Pyle is a former whistleblower and a professor of constitutional law at Mount Holyoke College. This has been Left Voices for Thursday, March 13th, 2014. Join us again tomorrow for more news and information from a progressive perspective. I'm Andrea Sears for leftvoices.net.